Yeah, hi friends, it's Harpreet Singh from Western Law Firm. Today I want to talk about a very interesting topic and a very, I think, common one people ask a lot, I think probably to every law firm. Can I represent myself in a general civil case? We have talked about small claims. Obviously, you will represent yourself in small claims court. But what about the other civil cases? It's either limited civil case or unlimited. So, so that's, I think, one of the questions which you hear a lot. I think because obviously the client is thinking about, do I need a lawyer for these kind of things, or it would be a good idea to represent myself? So I think one of the most important thing when you are thinking about these questions, so there are, I think, different points I like to go over. So first is you have to just look, do you have the ability to represent yourself? And when I say about the ability, do you have the legal acumen, or do you have some basic understanding about the court system, the civil justice system, what is the process, what are the basic steps? Because obviously if you have went through, I think, at least few of I don't know, an average person would not have probably went through even single lawsuit, but still, did you went through in some way or another? Either you were a plaintiff, defendant, witness, or a juror, or in some other fashion you have dealt with this particular system, which have a very systematic procedure how to proceed in the case. Because obviously people have, I think, the understanding of legal system from either the medias, movies, or this pop culture. So they only understand means they have this case filed against them. Now they need to defend it, and they are thinking, okay, I will just go to the court and just present these bunch of documents, and I will just prove to the judge means I am right. I understand your feeling. I think if you would be fighting or defending yourself in a small claims court, obviously that's that's the platform, or I think the process probably that would fit in. But if you are talking about a general civil case, either a limited civil case or an unlimited civil case in California, there is a procedure. Means it's just process of filing bunch of documents, receiving documents, responding to them. It's just the series of receiving, sending piece of documents. And sometimes it's very frustrating for an average person to know, who doesn't understand anything about legal process or how a general civil case move forwards. They will just think about, okay, why I'm not getting my day in the court, because that's not how the procedure has been set up. Because obviously in a general civil case you get a complaint. If you're defending a lawsuit, somebody has served you that. Now you have 30 days to respond. Now you have to file an answer or a motion. After you're done with that initial stage, then you have the discovery phase, where the other side, the plaintiff, is asking you a bunch of questions, and you have to respond them in writing in a proper manner. There are also rules for that, what's a proper response or not. So there are like bunch of rules which an average person obviously don't understand. Even as a lawyer, means we have to go through training of number of years, and even on daily basis we learn a lot of things, because it's just based on argument. It's just these one piece of rule which reasonable minds can differ, and they can try to interpret based on their preference. Obviously when you are I think interpreting rules, you are just trying to see means how you can defend your client or how you can proceed with the case. So you are just trying to interpret those rules in a reasonable manner, and reasonable minds can differ. There can be different interpretation you can come up with. So you have to understand all these rules when you are moving forward with your general civil case? And do you have the ability of that? Do you have, I think the second thing, a time for that to just go through the books? Because there are few of the I think how-to guides there to just provide you basic information, but you have to understand, do you have time for this stuff? And the second thing, it's most important, the cost and benefit analysis. You have to think, okay, this lawsuit is filed against me, so what are how much is the damages in question? Because if damages in question is $50,000 or $200,000, obviously I will caution you to at least get a consultation with a legal professional, and then think about if you want to represent. And I will advise you again, because the consequences, I think it's much more. $200,000 is not, I think, a smaller amount, even if you have a strong defense, because consequences is a lot to I think just go over. So if suppose in case you have like a $5,000 case filed against you from a debt collector, usually because debt collector usually go through general civil case and it's a limited civil case. So yeah, the cost and benefit analysis in that situation, it's quite different, because the damages are low, and obviously $5,000 is big amount for an average person, but still I think if you are thinking about, and probably that's the case, maybe you can work on yourself. Obviously you have to learn things, because still the procedure is involved and you cannot defy the procedure. And the judge will provide you leniency at I think initial stages of the case, but obviously if you keep on losing track of these rules, the judge will point out, and the judge will start get frustrating about it. And at certain point, if suppose you miss couple of hearings, if suppose you have filed the case, you are plaintiff, judge may dismiss your case. Even on the defendant side, if you are after providing notice, you are not going to those hearings, the judge may provide a dismissal based on court's own motion. So you have to keep track, and there could be sanctions because of the discovery rules. For like number of months you are not providing these documents, and judge has mentioned you, I think once at the hearing, judge provided you more time, still you didn't produce the document, because you don't have any idea like what to do, what responses need to be made, what's verification, so how to proceed in these situations. So you have to think about cost and benefit analysis. What's your suit, what's your issue, and how much are the damages. Is in some of the lawsuit there are no damages, there are certain things, probably there is some preliminary injunction involved or temporary restraining order. So these are like equitable issues involved in the situation other than damages. So you have to think about the consequences, and at least you can only think about it because obviously you are not legal professional, so you don't know until someone will tell you. So I think it's required. I can say, and I will highly advise that you at least should meet a legal professional, at least get an initial consultation about what's going on, what you are getting into, and what are the consequences if you will lose. So you need to, I think just follow that advice. At least it will not hurt you. 1 hour consultation or 2 hour consultation compared to hundreds and thousands of dollars. So I think it's still cheap. But I think you should get that advice before taking any step in your case to understand what's going on and what you have to do. So another option you might have, and it depends on the legal professional, you can, I think, enter into a limited scope representation. If suppose you have the first point, you have the legal knowledge, or you have been through the civil process a lot. Maybe you have been defendant or plaintiff, and I think some part of it, or if you are paralegal because you are obviously in legal industry, or if you are a law student, obviously law student have, I think I think that urge to fight each and every point. So I think if you have that legal knowledge, you have went through the system, at least I think you should get consultation, and at max I think even if you consider to move forward on your own, a limited scope representation that provides you like an ongoing consultation from a legal professional, so at least you can understand the step. Okay, what's the next step? I received this complaint, what to do next? Just file an answer. Obviously you need to know the answer and you need to research and investigate your own fact to defend yourself. If you're not using some legal professional, obviously you should get advice, and you would be advised to file an answer, or based on the complaint, okay, you can file a demurrer, or you can move forward for a motion to strike. So there are like different options which a legal professional can discuss with you, and if you know how to draft these things, obviously I think you can enter into an ongoing consultation agreement with that legal professional, like, okay, I have filed already my answer, so what's next? Discovery, like what I have to do, because there are forms for discovery, but for some of the discovery obviously you have to draft on your own. Or you can ask legal professional, okay, why not you draft it and I will represent myself in court. I would be the main person and the and representing myself as proper, instead of I think the legal professional getting into it, because obviously it will require time. So you can divide those assignments. It's difficult, I think. Some of the legal professional will not even, I think, entertain any kind of limited scope representation, because obviously it's sometimes gets very hard depending on the case. Like what's that border between your assignment and the client's assignment? So sometimes it get difficult to understand. So legal professional, just as a caution, they just like to, okay, I will represent you, otherwise I will not even just enter into this case, I cannot draft things, but I can provide you ongoing consultation, but I will not enter into any other situation, because there are a whole lot of stuff, deadlines going on, and you will don't know about this thing, because it just needs, I think, that training or number of years even to understand this stuff and structure. So if you enter into, I think you're going through legal industry, or you are already in the legal industry from number of years and you understand all this process, at least you should have consultation, and there is an option for limited representation. So again, you can represent yourself in court, but obviously you have to think about these points, either it's cost benefit analysis, what's the consequence, what at stake, and what are your options other than a full representation from a legal professional. So this was the video. I think probably a few of the people who have asked me this question have got their answers. So in next video, again, I will talk about another topic, which I hear more questions from prospective clients. So I can provide you that general legal information, so you can at least have some understanding before, I think, you go to a legal professional. It's easier and less time consuming, because if you are educated on general legal information, then I think it's very helpful for you, because your time is not wasted, and also your legal professional can help you, I think, in a better way, and also without spending more time can just move forward in responding to your case. So thank you again for watching this video.